Okay, we're live and we're just waiting for the participants to join. Still a couple more participants joining, so we'll give it another couple of seconds.
Okay.
Okay, maybe we'll get started. So welcome everyone to today's webinar on UNCITRAL's and ICSID's draft code of conduct for adjudicators in investor-state dispute settlement, hosted by the Inter-Pacific Bar Association and specifically the Investment Arbitration Subcommittee. My name is Lars Markert. I'm a partner at Nishimura & Asahi, and I'm joined by Kshama Loya, who is a leader in the dispute resolution group of the Indian law firm Nishit & Desai. The two of us will be double hatting tonight in our roles of one co-chairs of the subcommittee and two as moderators of today's webinar. For some of you tonight, for some today. Now, in a moment, Kshama will introduce our panelists and we'll then ask a number of questions to them to elicit some interesting comments on the draft code of conduct. But first, we'll have the pleasure to be greeted by the leadership of the Inter-Pacific Bar Association. And on the one hand, that will be IPBA's president, Jack Lee, who is with us tonight. He's been steering the IPBA with a steady hand through quite a difficult year, as you can imagine. And secondly, we'll have Hiroyuki Tezuka, who is a past co-chair of the Dispute Resolution Committee and basically the spiritus rector who had the idea for the subcommittee, and therefore we'll say a couple of words on that. But first, President Jack Lee, if I may pass the floor to you.
My dear brothers and sisters, dear distinguished guests, I'm very glad to have this opportunity on behalf of the Inter-Pacific Bar Association to thank all of you to join our IPBA webinar at this special moment. COVID-19 virus has been spreading out around the world, but the virus cannot stop our mutual communication. Today, our seminar focuses on the ICSID and UNCITRAL draft code of conduct for adjudicators in investor-state dispute settlement. The moderators are Lars Markert and Kshama Loya. The speakers are my Korean friend Kevin King, Secretary of UNCITRAL, Anna Lobling-Brett, Secretary General of ICSID, Matt Kinner, and General Counsel of the Trade Law Bureau, Sylvia Talbot. ICSID and UNCITRAL recently released a draft code of conduct for adjudicators in investor-state dispute settlement, addressing matters such as independence and impartiality, and the duty to conduct proceedings with integrity, fairness, efficiency, and civility. I do think this joint webinar with prominent speakers from private practice, government, and the institutions will attract more attention among our IPBA fellows. Any comments on the draft code are welcome and may be sent to the UNCITRAL Secretariat and ICSID Secretariat on or before November 30, 2020. We all know the COVID-19 brings plenty of efforts for global trade. However, through our tireless efforts, the whole world has already controlled the spreading of COVID-19, and the world trade has revived sharply. For instance, China International Fair for Trade in Service was held in Beijing early this month, and the conference attracted thousands of companies from all over the world. And the first Shanghai Bond FinTech conference was successfully held last week. And the seminar on the legal service for the Shanghai International Financial Center will be held tomorrow afternoon. The third China International Import Expo will be held in Shanghai this November. Hence, I believe the whole world will back on track very quickly. Next April, Shanghai will host IPBA 30th Annual Meeting and Conference at the bend of Huangpu River from April 18 to April 21st. We are looking forward to meeting with all of you in Shanghai. Before closing my opening remarks, I would like to share with you our IPBA new conference song titled, "We Are Together." Thank you. Please enjoy. We are IPBA, we are together. IPBA, we are the theory. IPBA, we are the family. IPBA, we are forever. IPBA, we are together. IPBA, we are forever. IPBA, we are together. Thank you very much for your attention.
Thank you very much, President Lee, also for the nice surprise with the song.
Thank you.
With that, I'll hand over to Hiroyuki Tezuka, also for a couple of greeting words.
Thank you, Les. It is my great honor and pleasure to make a few opening remarks to congratulate the leaders and members of the IPBA Investment Arbitration Subcommittee, IASC, on both its launch and its inaugural webinar with ICSID and UNCITRAL. I'm pleased to see that my dream of establishing a subcommittee on investment arbitration within IPBA has now become a reality. I am proud to have Shama and Lars as the inaugural co-chairs of the subcommittee. They have worked so hard to organize this historical event. I thank the co-chairs of the Dispute Resolution and Arbitration Committee of IPBA, Robert and Seyon, as well as all the new members of the subcommittee for their valuable support. I would also like to express my heartfelt thanks to ICSID and UNCITRAL for collaborating with us on this webinar, and I hope that there will be further collaborations among us. Diversity, inclusiveness, and friendship has been the spirit of IPBA since its foundation some 30 years ago, and is now also the spirit of this newly established subcommittee. I do hope that with these underlying values, IPBA Investment Arbitration Subcommittee will continue to contribute to the development of investment arbitration in or involving Asia. Again, thank you very much for your continued support. Thank you.
Thank you very much once again to President Lee and to Hiroyuki Tezuka for your opening remarks. And now I'll hand over to Kshama for the introduction of the panelists and introduction to this webinar. Thank you.
Thank you, Lars. It is my pleasure to welcome and introduce our stellar panelists for today. Meg Kinnear, Secretary General ICSID, Corinne Montanari, Senior Legal Officer, Office of Legal Affairs, International Trade Law Division, United Nations, Sylvie Tabe, General Counsel, Trade Law Bureau, Canada, Kevin Kim, Partner, Peter and Kim, Korea. Unfortunately, Anna Joban-Brett, Secretary UNCITRAL, could not join us today, but we are extremely fortunate to have a brilliant colleague, Corinne, in her stead. Meg, Corinne, and Sylvie have been deeply involved in the discussions of the draft code and will provide the institutional and government perspectives to the draft code. Kevin will offer the view from private practice, having acted both as counsel and arbitrator in investment arbitrations. With that, let us start the session by seeking the opinion of our attendees with a poll. Once we launch the poll, participants will have 60 seconds to vote. Please note that we have 2 polls through the session and a special poll at the end. These polls are precursors to our questions and will inspire responses from our panelists, so please do vote actively. After the first poll, our panelists will share their interesting perspectives on the questions Lars and I have for them on the draft code. And if time permits, we will have a Q&A session for our attendees after the final poll. With that, let us launch the first poll. Do you believe that the draft code of conduct for adjudicators offers an effective framework to regulate contentious issues relating to adjudicators in investment arbitration? Please select the appropriate option, yes or no. Thirty seconds to go. Thank you. Can we have the results, please? Great. So 89% have voted that the draft code does offer an effective framework to regulate contentious issues relating to adjudicators. So with that very positive note, let me pose our first question to Corinne. Corinne, what was the driving force behind formulation of the draft code of conduct?
Yes, good morning, good afternoon, good evening to all, and thank you for the beautiful song. Thank you also for the very comforting results of the poll. Indeed, the code of conduct is usually a good way of addressing these topics, but what we need to dig in is into the details and make sure that we are addressing correctly for everybody, and there are different stakeholders, the concerns. So I think, as you are all aware, both ICSID and UNCITRAL have done work for the revision, for ICSID, the revision of its rule, for UNCITRAL, consideration of the possible reform of the ISDS framework. And as part of this process at UNCITRAL, there were delegations, and delegations are composed of states, members of the United Nations, and international organizations, intergovernmental and non-governmental. So these delegations have expressed first what they see as concerns with the question of the ISDS regime. And this is based on these concerns that reforms are being developed. And many of these delegations raise the concern that we need stronger ethical requirements for ISDS tribunal members, not limited to arbitration practitioners, but to all those who are decision makers in ISDS, whether in the current arbitration regime or in any future body that could be created as part of the reform process. And so in the submissions that many states have made in writing that you can find on the website of UNCITRAL, a large number of these submissions mention the preparation of a code of conduct. For instance, the EU and its member states, Morocco, Thailand, Israel, Chile, Japan, Costa Rica, South Africa, Ecuador. Many delegations mention the need for such a code of conduct. So what you have in front of you is the result of a joint work by the secretariats of ICSID and UNCITRAL at the request of delegations, saying we need a kind of unified standards on this topic. And after that request, what we have done with Megan and the team is to prepare a paper raising questions on what should be covered by a code of conduct. And then last year in October, the working group looked at these questions and gave directions. And this is based on these directions that we have prepared a draft, which is just a draft code of conduct which will need to be considered in the wider framework in which it will operate, which could be arbitration or which could be something else, but we can come back to that later.
Well, let's maybe stay with arbitration, and I'll pass the next question on to Meg. And one question that kind of came to mind was, when reading the code of conduct, was how does that draft code interact with the ICSID convention, with the arbitration rules? There is also currently an amendment process. So how does that tie together when we talk about arbitration?
Exactly. Well, thank you. First, I wanted to say that we're delighted to be part of your inaugural webinar, and congratulations to you for getting this wonderful initiative off the ground. To answer your question, I think first of all, in terms of content, the code is definitely consistent with the ICSID Convention, which has a basic obligation in Article 14 to be of high moral character, have competence in the law and related topics, and to exercise independent judgment, which is of course independence and impartiality. So I think at the broad level, it clearly is very consistent. Obviously, much is going to depend on the final contents of the code. And I can think of, for example, a situation where if delegates decide to have a full prohibition on double hatting, one might say, well, how does that consistent with the ICSID system, where you have arbitrators named to a panel by the member states, and many of them are practicing counsel? How will that be consistent? I think perhaps that creates more of a practical problem than per se a legal one. And I suspect those are the kinds of things that we will be able to get through by transitional provisions or adopting certain practices. But you can see how there will be some overlaps, but a lot will be content specific. In terms of implementation, I think, again, the form of the code is going to be significant. So, for example, there's been some discussion that maybe this would be implemented through a Mauritius type convention, in which case that would govern implementation, and it would not really be a question of the ICSID convention per se, but it would be a broader new treaty implementing this code. At this point, knowing what we know, we've assumed that the code could be fairly easily implemented. And what we've said in our amendment process is that it could be attached to the declaration by arbitrators, which is in Rule 6, and that would really be an easy way to incorporate by reference the entire code. In terms of enforcement, again, as currently proposed, the challenge and removal rules in each applicable set of rules is what will govern, and so there is no procedural conflict. So I don't see any real problem. Obviously, it's something we've got to keep our eye on, and our expectation certainly is that there will be at least agreement in principle through the Working Group 3 discussions, and then we at ICSID will have to take it to our membership and say, do you want to implement this? And if so, how do we implement? Is there anything specific to the ICSID context? But we've got a bit of a road to walk first before we get there.
Thank you so much, Meg, for shedding light on the interplay between the two. Sylvie, how does the draft code assist states like Canada that have already implemented codes of conduct in their newer investment treaties, like in CETA or the Comprehensive and Progressive Agreement for Trans-Pacific Partnership?
Yes, thank you. And let me just add my thanks for having invited me to your inaugural meeting. I'm very, very happy to be here with you today, this evening in Asia, where I'm located. Well, just to answer your question, I think it really goes back to, why are we developing a code of conduct? And as Corinne mentioned in the UNCITRAL working group, one of the issues that a lot of states, the concerns that states shared was, we need a code of conduct to enhance the confidence in the ISDS system, and we need harmonization. So the first point is really about the enhancing the confidence. And one of the difficulties we have seen and in addressing criticism of ISDS is that even if problems arise only in a few limited cases, it creates a perception that the system as a whole is not legitimate. And so, for example, the fact that in some awards appear to be unfair, and it could be because the treaty is poorly drafted, that affects the ISDS, what is called the ISDS system, although some people hesitate to call it that, but it does affect the perception of it as a whole. And this is also true in the context of adjudicator conduct. Even if only some arbitrators engage in some practices that are problematic, or in conflictual situations, it creates the impression that this is generalized and this is the system is biased. And so we need to address that. And that's why even if we address the issue in some of our treaties like CETA and CPTPP, it really only addresses part of the issue because the system as a whole, the problems of perception are not addressed. Now, the second point I wanted to make is that, in fact, not all of Canada's treaties have codes of conduct. It's relatively a recent addition to our treaty practice, and this is an issue for many countries, including the CPTPP countries like Japan and others. So our older treaties do not have codes of conduct, and we need to address that. And there's a question of how do you do that? It's very time consuming to go back and amend all of your previous treaties. So it could be done through potentially things like amendments to the arbitral rule, as Meg was mentioning, if it were incorporated in ICSID. That would solve part of the issue. But that brings me to the third issue, which is the harmonization. And really, even if you address ICSID, there are a number of other arbitral rules where you would not fix the problem. And so we really want the code to apply to all ISDS, all investment arbitration, even if they're under different rules and under different treaty, to create some uniformity and certainty for all the parties involved.
Okay, thanks, Siri. And maybe that, again, is a nice lead-in question for Corinne. When the discussions are now happening in the working group, is there an idea how to make this code of conduct uniformly applicable, a mechanism? I think Meg already mentioned one option. Is there discussions about this?
Yes, thank you, Lars. Yes, it's true that this topic is of independence, impartiality, regulating conflicts of interest. It is not new. We find that in rules. We find that in the IPBA also guidelines on conflicts of interest, and it's dealt with in treaties. So we have many different standards already out there. And I think the purpose of the work was to say what Sylvie just mentioned, to have something which could be a little bit more uniformed. So we don't have this slightly different wording in different standards, and we don't know why they are slightly different. Maybe there's just no real reason behind that. And so the first point is to say, is it possible or not to have a code of conduct that would satisfy everybody as long as we have an ISDS case. So we are trying it, and we are very pleased to work jointly with all those concerned and jointly with the ICSID Secretary to try to do that. This topic of uniform implementation has not been discussed yet in the working group. Meg mentioned it briefly, so it is too early to say that we have already a plan to do that. But what we have is, what Meg and Sylvie have mentioned, is the project, and that's something which is going to be discussed next week in the session of Working Group 2, is to develop a multilateral instrument on ISDS reform, which would contain various parts, which would cover different types of reform. We know there are different opinions on what should be reformed. Everybody agrees there should be a reform, but not everybody agrees on the solution. When all solutions can most probably live together, that's something we are really looking at, trying to find some consistency. And the idea of a number of delegation at this stage, but again, it has not been discussed, whether the code of conduct at least could be part of this instrument and could form also the kind of minimum package on which all states could agree. So let's see if we manage to do that or not.
Thank you, Corinne. We really hope to have some solution on this and look forward to the working group's discussions. So we've looked at the driving force behind the code. We've looked at how it interacts with other regimes. Let us now examine the code. Kevin, as a private practitioner and an arbitrator, can you share whether, and if so, how, your colleagues have reacted to the draft code?
First of all, I'm also very honored to participate this exercise. I'm not in a position to speak for my colleagues, but personally, I support, very much welcome this move and this code draft code, because this issue has been discussed and actually argued in actual cases for recent years. And we need some more clear guideline on this particular issue and some other related issues. So with this guideline, we probably sorted out issue relatively quickly, particularly when you have, we have one of the issue that the unfounded challenges or challenges by way of the delay tactic. When you have a clear guideline, then we can sort it out issue. And also, we can have more clear answer to the specific question, then they easily grasp the idea of what should be allowed it and what should be not be allowed it. So I really like the idea that we have a unified code on these issues. I believe that my colleagues would be the same thought I have. Thank you.
Well, I guess we'll just have to ask a lot of more colleagues of yours, and we'll see. Maybe another question for Corinne. If you would have to describe kind of what the key approaches of the draft code are, like what are the key solutions that the draft code proposes? How would you summarize that in kind of a impossible nutshell?
Yes. Yeah, thank you. I think it's difficult to summarize. The text is not very, very long itself, so it can easily be looked at, and you get immediately the impression of what we've been trying to do. We've been following the guiding principles that were given by the UNCITRAL working group. And so the guidelines, which are meant to ensure that the educators will really abide by the code, is that the code should be binding. It's not a soft law thing. It has to be binding. It's not just something optional that you can take or leave or do whatever you want. It has to be binding. And it has to contain concrete rules and not guidelines, because we had that debate. Should it be more in the form of guidance? And no, concrete rules. And it should provide for applicable principles, which you find, I think, in Article 3, but also detailed provisions, which are the rest of the rules of this code, which should also allow for flexibility. We don't want to say or to micromanage the decision makers for these huge cases. But the idea is to find a kind of balance. And what you've seen in this code is that we've been into more details regarding the question of double acting, which I think we'll discuss maybe later on a little bit more, and the question of issue conflict by providing more details. Is it the right level of details or not? That's really something for everybody to let us know and to come by, because again, this is a very, very first draft, so nothing is set in stone here. As I mentioned earlier, this code applies to all those who adjudicate ISDS cases, regardless whether they are arbitrators, members of annulment committees, members of an appellate mechanism, or judges on a bilateral or multilateral standing mechanism that could be created in the future. And I would again want those who read the code to really read that, keeping in mind what the challenge procedures may be in the different rules, how it is suggested to also reform the challenge procedures and to reform the way the arbitrators and decision makers could be appointed, selected. That's something that also needs to be looked at. There is a paper on the website of UNCITRAL, which is in the form of a draft also on that. And I would love really to have this type of webinars on these topics also. Just to say that the code is not, there's nothing new there also, because it has been, there are a few things which are really new, but it has been prepared based on the comparative review of the standards found in the Code of Conduct Investment Treaties, arbitration rules applicable to ISDS, and Code of Conduct of international courts. So the only thing which is maybe really new is this intention that we can feel in the delegations of UNCITRAL that they would like sanctions in case of non-compliance to be established. And we looked at that jointly with colleagues in ICSID, and that's something which we understand. But it is very difficult, at least at this stage, to figure out how any sanctions could work. Because that's what they were saying, it's nice to have all these codes with all these obligations, but if you do not have sanctions, then it's just like empty words. And I think that this is something also which needs to be looked at in the context of whatever other reforms may come into play. For instance, there are suggestions for reforms such as creating an advisory center. So some were saying maybe if you have an advisory center, it could be more or less involved in this type of things. Or to have rosters of arbitrators and with an institution responsible for these rosters. So people said well, institutions which are doing that could also find some, implement certain sanctions. But again, it's difficult because on which basis do you do that, and what kind of sanctions do you apply? So this will be the subject of a whole debate also to come.
Thank you, Corinne. That was an extremely helpful summary. You mentioned that the code is not set in stone, and I think this is the best part about the code. It's opening the code to the investment arbitration community to come back with comments, and we urge everybody to actively contribute to finalizing the code into a crystal clear framework. So thank you so much for that. Sylvie, my next question is to you. As a representative of the state, could you share some concerns that states might have with respect to adjudicators in ISDS? Do you feel the draft code sufficiently addresses those concerns?
Well, that's a good question. Obviously, I can't speak for all of the states, and I'll make some comments that are generally reflective of my government's position. But I think, as I mentioned earlier, the concerns are really looking at enhancing the confidence in the system and the perception of lack of legitimacy. And I think the code is an excellent contribution in many ways to address concerns with adjudicators in the system. It doesn't address all of the issues. So for example, there have been concerns about lack of diversity, regional and gender diversity in arbitrators. And the code doesn't obviously get into those issues. But it does address issues of competence, impartiality and independence, and even efficiency and confidentiality, maintenance of confidentiality. So a lot of very important issues. On competence, I think the code certainly provides a good basis for discussion, and there were various views that were expressed in the UNCITRAL working group by states. Some states feel that arbitrators should have knowledge of domestic law of the host state. Some feel there should be knowledge of public international law. Some want, very specific knowledge. So it's difficult to find something that will satisfy everybody. But in my view, that the code achieves the right balance in that respect. And I think on efficiency, some states probably would want to go further in terms of more hard limits on time or number of cases. But there is certainly, what is in the code right now is a good start for ensuring that arbitrators don't take on too many cases and regulate the number of mandates they take on. And I think that's very important. Now, independence and impartiality, I think the debate there will be really about, as Corinne mentioned, whether everything that's in there is very useful. There will be some questions as to, is disclosure sufficient? Does the code need to, for example, go into more detail about when the specific instances will lead to disqualification or raise a real concern? When this can be waived by the parties, or whether this necessarily leads to a disqualification. And that debate, perhaps we can talk about double hatting a little bit later, but certainly on double hatting and how far you go on double hatting will be certainly an issue. Now, having said all of that, I think some states will still find that, regardless of when you put in a code of conduct, there are inherent limitations in ad hoc arbitration that cannot be addressed only through a code of conduct, and that more systemic reform is necessary. And while the code purports to also apply to potentially to the adjudicators in a permanent mechanism, there is going to be a fundamental discussion to be had as to whether just imposing a code of conduct on the current ad hoc arbitration will be sufficient to address all of the concerns related to adjudications in ISDS.
Thank you, Sylvie. So taking a cue from Sylvie's point on sufficiency of disclosures, let's have a second poll on disclosure obligations under the draft code. Rhonda, could you please launch the second poll? Extensive disclosure obligations under the draft code would lead to an increase in challenges of adjudicators. Do you agree or disagree? You have 60 seconds. Thirty seconds to go. Okay, could we have the results, please? Okay, so 62% of our attendees believe that extensive disclosure obligations might lead to an increase or would lead to an increase in challenges of adjudicators. Thank you, Rhonda. So that brings me to a question and to your opinion, Meg and Sylvie. Meg, do you believe that extensive disclosure obligations would lead to an increase in challenges of adjudicators?
Well, I think your poll actually very well represents what I've been hearing in these kinds of discussions, and that is a concern. I certainly hope not, at least to the extent that those are unfounded or strategic challenges, as Kevin has talked about a few minutes ago. I guess, at least theoretically, it's not a bad thing to have founded challenges. That's, I guess, the idea of a code with a remedial provision. But really, the idea behind this is the opposite. The idea is that if you make the obligations more clear, arbitrators will know when to reject a mandate, and they will know when to make disclosure. And likewise, on the other side of the equation, parties will know much better when there's a legitimate concern, and when, if an arbitrator doesn't step down, they would likely be successful in a challenge, and therefore could bring a well-founded challenge. So I think the challenge, to use challenge in another way, I think the opportunity here, the requirement, is to make sure that we can make the obligations as clear as possible so it doesn't result in a lot of challenge. And what we hear today is, I don't know if this will be successful or not, so I have to challenge. And we want to try and address that problem first. I should also note that, interestingly, there is a link with the proposed ICSID rules right now, which in particular allows arbitrators to make interim cost awards. And one of the things that I think is worth considering is, to the extent that there are unfounded or strategic challenges, maybe that does need to be addressed through cost remedies or those kinds of issues? Because it's certainly something we hear from the practicing bar.
Thanks, Meg. Sylvie, I also saw you smiling at the results of the poll.
Yeah. Yeah, I mean, I think that's a tough question. I think it's possible that there will be more challenges. I also, like Meg, I hope so. I think more and repeated or unfounded challenges are not in the interest of the system. Generally, I think it is obvious that, providing for the appropriate level of disclosure, allowing people to have access to the information on an equal basis is a desirable goal. Now, you don't want to overwhelm arbitrators with, having to look for any potential conflict, even if they're not aware of anything. And even for the parties to an investor-state dispute, sometimes you have too much information, it gets useless. So you have to find the right balance. But generally, I think that disclosure that is being discussed is probably a good thing. There may be a few things where there will be some discussion, isn't necessary, how can this be done practically? But one of the comments I was going to make is I think early disclosure and clarity on what has to be disclosed will probably lead to, if not fewer challenges, certainly the challenges hopefully will be made earlier on, and so result in more efficiency and less cost. The last thing anybody wants is, well, certainly the situation in ICSID, the annulment of a case at the end of the day is not desirable, right? It's much better to address the issue early on. And so I think having the information would have, potentially addressed that at the time. Part of the challenge, as Meg says, and I think what we really need to think about is how to provide enough clarity to lead to fewer challenges. And I think that's going to be part of the discussion is, we want to provide enough clarity and specificity so that you don't have unnecessary challenges. But at the same time, you have to recognize that it's case by case, circumstance specific. In some cases, some parties may be okay with accepting some of the potential conflicts, others may not. So I think we need to do probably a little bit more work in terms of the discussion of, can we be more specific and yet maintain that proper balance?
Yeah, that will be a challenge, talking about challenges. Maybe one question to Kevin, and that's really about practicability of the provisions as we have them now. Since you actually practice as counsel and arbitrator, I just wanted to point you to Article 5, subparagraph 2, which contains some of the disclosure requirements, and I'll have it here. If I read that, you have to disclose about, of course, the parties, but potentially, if that gets adopted, any subsidiaries, parent companies, agents, agencies related to the parties. And a second thing I found interesting is that it basically would require you to give a list of all of your publications, but potentially also all of your relevant public speeches. And I haven't really counted, but I had the impression, Kevin, that over the last 20 days, I saw you speak at least 10 times at webinars. So I was wondering, how would you go about that?
Yeah, I must say that I have nowhere to remember. Well, actually, the difficult thing might be the public speech. I don't know whether it's counted as public speech, but I think I should hire someone to check for what I did for actually 30 years, and actually self-applied publication is quite challenging. But at least if I required to do that from now on, I'll do that. I carefully check and remember. Put the record every public speech and a publication I'm doing. And actually, as to the party issue, subsidiary parent company agent it's also very challenging. If you're dealing with Asian companies, as you know, the group of companies is quite big, and sometimes same name, totally separate company or totally separate group, but different name, actually subsidiary or the parent relationship. So that means that we also pay attention to the very long list of the companies and possible agent. Again, very practically, we should do that if you start to apply this code, and I should, as much as I can remember, I have the long list of the companies I personally involved in, and keep the record. Maybe put that information on public, subject to the confidentiality obligation. So that is quite challenging. But once you make that clear guideline, I still think it's a good thing. If you are required to do that, we were going to do that. The thing I really hate is we are arguing about whether we have the obligation to disclose or not. And this idea was discussed. Somebody said you must disclose all the publication or parent company things. And so we should have clear guideline on that issue. That I welcome. But I must say that this is quite challenging, practically to someone. You should have some reasonable period or somehow some restrictions on that issue.
Thank you, Kevin. Meg, what are your comments on Article 5? What do you think?
I think Kevin's points are well-founded, and I think perhaps I was a little surprised, but I totally understand now. We've heard a lot from arbitrators in particular saying this is a very high level of disclosure and they're concerned about how they will address it. And I think it's interesting. I think there are ways, and we should be thinking more about this, but obviously extensive disclosure in and of itself is a good thing. And it is very possible, for example, some arbitrators keep what you might call an evergreen curriculum vitae on their website, and you just add on as you go. And maybe we need to think about, you disclose your CV at the time you take on an appointment, and then have the parties responsible for checking that evergreen CV as the case goes along, once the case commences. But the fact is, the arbitrators are the ones who are in the best position to make disclosure. They are the only ones who really know all of this information. And we know realistically that parties are going and Googling, what speech did you make and what article did you write? Why do we have to do this every time? Why not just have an evergreen list, keep it going? I do take Kevin's point quite well about a transitional provision. No one should be expected to remember 30 years ago, but maybe going forward, once we get the code in, it's very simple to keep that kind of an update CV. So no, why not make it easily available? The other thing that's got to be remembered here is that, as we've said in the commentary, the mere fact of disclosure does not mean there is a breach, or even that the arbitrator thinks that there is a breach. And perhaps it would be wise to actually put that in the text. But the idea is get the information on the table for the parties, and then it'll be up to the parties to decide, is that relevant? So you won't have the arbitrator saying, well, I won't disclose this speech because I don't think it's relevant. Put it out there, let the parties decide. And I think it's not as onerous as some are concerned about. And that's something we have to consider in the design to make sure it's easily doable.
Thank you so much, Meg. Corinne, what was the idea behind expanding disclosure obligations to a period of 5 years compared to the 3 years in the IBA guidelines? Can this effectively curb repeat appointments, particularly on the state or investor side?
Yes, I am not sure that 5 years instead of 3 years will have such an impact on the repeat appointments. I think for repeat appointment, there may be other devices to deal with that. Again, I would say it is not set in stone. So it is 5 years because it seems to be a reasonable period of time, not too short, not too long, given the complexity of the cases and their ramifications. that will be discussed. I mean, all these durations, all these things which are in the draft code are really for states to consider and discuss, and there will certainly be a discussion about the advantages and drawbacks of 5 years compared as opposed to 3 years, as opposed to 10 years. So we will have these discussions, and we will see what comes out. So my reply is very short on that. Let's wait and see.
Well, it can be sometimes the best answer. I usually give that answer. Okay, maybe we'll run the next poll. We're switching to one of the hot topics, double hatting. If we can pull up the poll, I'll explain that quickly. So as many of you that have looked at the draft code have seen, Article 6 addresses limits on taking up multiple roles, such as being counsel and arbitrator at the same time, which is normally in short called double hatting. And there's currently in the draft, there are 2 ways in which that can be done. One, you can prohibit double hatting altogether. So once you've been a counsel, you cannot be an arbitrator. And the question is always, is that in parallel or at some kind of cooling off period? Or you basically say you require disclosure of double hatting. So if we can have your vote, please. Okay, and we'll give it another couple of seconds. All right, Rhonda, can we show the results? Okay, there's a pretty clear outcome here. 77% of all survey participants said, well, we rather think disclosure of double hatting is appropriate rather than a complete prohibition. So let's discuss this a little bit and see what is the general sentiment. So maybe Sylvie, starting with you, and I want to take the issue a little bit further and ask you the question: should we be even talking about double hatting, or is that not better addressed in a different way, just by a very strong conflicts provision or disclosure provision? What are your views on that?
Right. Well, so just going back to what I started with, the concerns about that we're trying to address here, and double hatting is certainly, again, using that term loosely, but these kinds of concern about playing multiple roles in the system have, and in particular, the arbitrator and counsel have certainly consolidated a lot of the criticism around the ISDS system. Whether that's founded or not is, I think, can be debated, but it gives the appearance that there's a bias in the system. I think the practice needs to be regulated one way or the other in terms of whether disclosure is sufficient. Potentially disclosure of prior appointments as counsel, if a candidate is being appointed as arbitrator, makes sense. Maybe a transitional period for ongoing mandates. The problem is if you have disclosure and a candidate is appointed as arbitrator and then takes on new roles, it's very difficult for the parties to object, and it could be really inefficient if it happens late in an arbitration. There's a risk that it will not lead to disqualification. The parties feel very uncomfortable saying no later on to an arbitrator once it's disclosed or taking issue with it. So there are a lot of risks around that. And as a result, Canada in its treaties like CETA and CPTPP has imposed a prohibition on double hatting, if you will. Now, I think we should have a bit of a discussion about what the scope of that is. Should be arbitrator and counsel, arbitrator and expert, for example. And in our view, it should certainly be limited to all investment treaty arbitration, but not extend to, for example, commercial cases where the same concerns do not arise. And the reason for that is that in the investment arbitration, there's really a limited number of issues that are decided upon over and over again. So the possibility of conflicts arising out of that are much higher. Now, I think once an arbitrate, there are, and I don't mean to minimize the concerns that are related to imposing a blanket prohibition, because I think we've heard from many, including many states during the UNCITRAL meeting, concerns about whether this has an impact on like diversity and other objectives that are being pursued. So we do have to be mindful that it doesn't have an unintended effect.
Okay, thanks, Sylvie. And of course, Kevin, you won't be surprised that I'll be asking you the same question as you are the one that might be directly affected by that rule. What is your view on that provision?
I'm conflicted to answer this question. It's difficult to say, but if you have a clear rule that the double heading under what circumstance, or just have a clear disclosure obligation or clear prohibition, I think it's a good thing. I just make a clear rule on that issue. The commercial arbitration totally different, but investment treaty arbitration, we have repeated issues, and it's difficult to say whether there is an actual prejudice or not. I personally, I don't think, somebody have certain view on a particular case, not necessarily he or she might have the view on different case. But from users' point of view, they might have concern. So if they say, you shall not take the position of both, if that is the user's demand, I think we should accept. And if the market or the people just believe that this is right way to enforce it, I have no problem with that. It's like I think if we just have again the clear idea that what should be allowed, what should be not allowed, and disclosure should be a very important thing. And as to the objection, I also agree that it's difficult to object in the course of arbitration. And actually, I act as counsel. I have same difficulties. At the same time, we see many cases where some tribunal members just resign in the middle of the case. That disrupts a lot of the cases, and then new arbitrator or adjudicator or in the committee, it just can't just join, and then it just extend another procedure. That also become one of the big area of the complaint by users. So we should have right balance between these double heading issues together with that procedural efficiency.
Thank you, Kevin. Sylvie mentioned that we need to be mindful that the draft code and the double heading provisions do not have any unintended consequences, such as on diversity. That brings me to a question for you, Meg. Do you believe that the draft code's regulation of double hatting could have an impact on gender and geographical diversity of potential arbitrators?
Yeah, I think in the commentary does note that this is a realistic concern. I'd preface all of this with the fact that I suspect that double hatting, or the incidence of double hatting, is reducing just naturally in the profession now, and with the awareness of this kind of discussion. But there is a realistic concern about the impact of a prohibition on double hatting and diversity. And that is largely because many of what you might call the first timers, or the ones who are new to sitting as arbitrators, could not realistically be expected to give up all of their sources of income when their first case comes along. the statistics on how many people only have one case in their career are quite daunting. And this is particularly obviously the case of arbitration. Wouldn't apply, for example, to a judge who has a full-time salary. But in arbitration, it's not realistic to expect somebody to give up all their other sources of income as a practitioner for their first case and hope that they're able to establish themselves as an arbitrator. So I think there is a realistic question about how it will impact diversity. We've heard some ideas about could you have a transitional provision, and that may be a way around it, although it's difficult because if you truly think this is a conflict of interest, it's also hard to say, but it's an okay conflict of interest for the first 5 cases or the first 5 years. So it's something we're going to have to look at more carefully. I think it also will have a large impact, especially again, the full prohibition as opposed to disclosure, on the kind of expertise that gets brought into the pool of arbitrators, because it will obviously be the practitioners who are the most impacted by this. And so there have also been discussions about what does it do to the overall profile of who are your arbitrators. So a lot of questions come up in particular with the full prohibition on double hatting.
To maybe add another question when it comes to a full prohibition of double hatting, and maybe I'll ask that to Corinne. And it might be a bit of a cheeky question coming from the mouth of a practitioner, but if we do have a full prohibition and you see people like young people getting involved as counsel, so probably the road to arbitrator is blocked. Do we then only have professors that can serve as arbitrators later?
Thank you. Yeah, thank you for this question. I would just like to recall what Sylvia said. This question of double hatting is a very important issue, and it was seen by delegations, state delegations, at the kind of key aspect regarding the legitimacy of the whole system, and in particular, the effect it may have on the perception that outsiders have on this investment arbitration system. And there has been many different views expressed on the impact of a double provision and double hatting, whether it is a prohibition or a regulation. And clearly, I think we fully understand the concerns which are raised by the professionals in this field, because this is how the system has been working, and this is how you have ensured that there are new generations of lawyers coming to this practice of being arbitrators. So we understand how difficult and important this question is. Maybe I just wonder whether it's a little bit. It is important to look at this question in the code of conduct, but again, I think this question needs to be also considered in the wider context of how this election appointment of ICSID tribunal members will be reformed, if it is reformed. Again, there is a new paper on this topic, and in this topic there are some suggestions on how the system could be slightly reformed so to encourage younger practitioners to become arbitrators. There are different ways of doing it, like having younger people sitting with the arbitrators, not being part of the arbitral tribunal, but being like auditors, you know. You have that in certain courts in certain parts of the world, or having a system for really training of younger practitioners to become arbitrators. So there are many different ways of doing it, and I think we need to find the right balance. And whatever we do, whether it's prohibition or disclosure, we will have to define what is the scope of double hatting, and that will make a whole great difference also for the practitioners.
Yeah, I think the scope, that will be a very interesting question that we cannot resolve tonight. Maybe, so we see we're running a bit short on time, but maybe we can still address the question that came up earlier already, that Corinne, for example, has mentioned about the enforceability of the draft code. What can we do to actually bind the adjudicators and to give that draft teeth? And maybe Meg, do you have some suggestions about that?
this was one we wrestled with. It's very hard to know how you make it enforceable when you don't know exactly what you're enforcing. So I think we have to deal with the first part first and get that pretty well nailed down. But certainly the instructions we were given was to make this binding and enforceable. Currently, Article 12 simply provides for a voluntary obligation to comply, obviously, and the challenge and recusal rules of the applicable set of rules to the case. I think that is a way of making something binding and enforceable. And the real question is whether you go beyond that. We've heard various suggestions, things like, would the advisory center play a role? Is there some kind of a disciplinary role? We didn't go that far in this first draft because it is very hard. There's big questions about jurisdiction, about legality, about the impact on freedom of selection of your arbitrators. So I think this is a tough question, and we'll see what delegates want to do with it.
Well, one of the delegates might be Sylvie. So what do delegates want to do with it?
Yeah, I mean, I completely echo Meg's comments. I think this is really a difficult question. And even when we get it, I think, as Corinne said, there's a general feeling, a very widely spread desire to have this binding. But what binding means to different states is probably slightly different. I think many states could be satisfied with a disqualification procedure if there's non-compliance with some of the obligations, right? Not all of the, you know, if a minor disclosure was not complied with, does that necessarily lead to disqualification? Probably not. It wouldn't rise to the standard for a disqualification. So then it becomes a bit trickier for those other provisions. And, you know, maybe various ideas have been thought about, like, do you have transparency for people who are not complying, and therefore that could lead people to make an effort to comply if the next, you know, when they're next being considered for as arbitrator, people will know that they haven't previously complied with the code. How that gets operationalized is a bit of a challenge, obviously. But so is, you know, sanctions. People have talked about different kinds of sanctions. Some states suggested monetary sanctions, or and that really, I think, that will tie into how the code is implemented and how far you can go is going to be, as Meg said, a bit of a challenge.
All right, Kevin, you as a lawyer, if you want to make something enforceable, how do you draft it?
I think, you know, we should be practical. As the this type of exercise, joint exercise, we discuss about rule or draft code. People become quite enthusiastic about putting all ideal things in the code. But once code is made, it should be applied. So in order to make sure that that rule should be accepted by the market, and actually all people will follow with rules, the rules should be practical. So that's something like we should somebody make sure that it does not cause an unnecessary burden to the parties and arbitrators and counsel. And once it's established, I believe that whether or not we try to put it like binding or not binding, or mandatory, not mandatory, in practice, it will be treated as very strict rules. Everybody will challenge based upon these rules. Everybody decides based upon that interpretation of the rules. So that that is the quite important thing. So all successful rules are based upon the practical approach.
Yeah, it's thank you for that. Maybe Corinne, you already addressed it, but if you have kind of one or two closing ideas on that.
Yeah, no, I won't be long on that. I think everything has been said. I think we need to be aware of the spillover effect that whatever we do in investment arbitration may have on purely commercial arbitration, and that we have to be very cautious. And that's for you in the arbitration community to make sure that things remains as they should be. so that there is no such a spillover effect where it's not necessary.
Thank you so much. We've had such interesting and different opinions from our panelists. I think it's the differences that actually make it worthwhile to finally bring a balance, and hope that the final code actually brings that balance. So with that, we come to the closing question before we move on to our special poll after the webinar. And this is to all panelists. What would be your one key recommendation to strengthen the draft code? Maybe we could start with Corinne, followed by Meg, and then Sylvie and Kevin.
Yeah, I will not be addressing specifically what could be done to strengthen the draft code, because for me, the concern I have at the moment is to ensure that all the reforms we have on our plate, and we have a number of them, as you may see on the website of UNCITRAL, there are many different reforms which are being considered, that all that is consistent. And I think we need to see how the draft code of conduct goes into these overall discussions on the reform options. That will be my closing words.
For my part, I think that the key thing right now is to drill down into what is and isn't okay. And in some respects, the arbitration community, the ISDS community, going to make some hard choices. It's okay to have repeat appointment. That's it. Or it's not okay. But we need that kind of clarity so that we've got something that's very practical to apply. And there are a lot of judgment calls there, or policy calls. We'll have to see how that works out. And one of the things that's really hard about this field is, and it sounds like a bit of a stereotype, but it truly is fact dependent. So it's very hard to say absolutely this is okay, because it depends, but a useful code would not say it depends. So that's the key recommendation, and I think what we have to do in our next steps.
Sylvie?
Well, I won't be very original, but I do actually really wholeheartedly agree with the comment Meg just made. And also picking up on what Kevin said, I think buy-in from the community on this code will be crucial to have it implemented and to make sure that, you know, it gets put in place. So I think, you know, the discussions we're having with this group and elsewhere are tremendously important.
If I want to say something, just like I'm not using the minimize, but try to find the key crucial thing we should do right now, and just focusing on that in the code. And once this code is adopted and start to apply, then we can extend. You know, there's something more reasonable. So I would say that we just stick to that the very, very important factors, and the conflict and disclosure and double heading. So we just like focusing on that, just narrow down the key elements of the code. That would be, I think, the better approach. Thank you. I really enjoyed this exercise.
Thank you so much. We did have a bit of a Q&A, not much. I think one question was about the very extensive disclosure arguments. So I think that one we have answered in a way. But there was one question we wanted to pose to you, and I guess that's a question to Meg. It states, does ICSID plan to move ahead with the code independent of UNCITRAL Working Group 3? If so, is there any timeline to move this forward in ICSID?
Yeah, this all came up for ICSID in the context of the scoping exercise for our amendment process, so it came up independently. But we also saw it coming up in Working Group 3, and in a topic like this, harmonization is so key. You do want sort of a universal set of ethical obligations, which is why UNCITRAL and ICSID decided it was a key one to work together on. So our preference at this point is to see it mature within the Working Group 3 process, where we are definitely participating and most of the same players are participating. If for some reason it did not materialize in that context, I think we've still had it raised in the ICSID amendment process, and it's something we would have to come back to and say to members, would you like to pick this up and keep going further just in the ICSID context? But at this point, it appears there's every likelihood it will be dealt with in this larger context, and I think that's everyone's preference for harmonization.
Okay, thank you for that clarification.
With that, we come to our special poll. So let's have the final poll. Rhonda, could you please launch it? And why is it special? Because it's the first poll that we ran. We're just seeing if the views have changed after the webinar. So now, do you believe that the draft code of conduct for adjudicators offers an effective code to contentious issues relating to adjudicators in investment arbitration? Yes or no? Ten seconds to go. Thank you. Can we have the results, please? Wonderful. The initial results were, if I recall correctly, 77% agreed, which was what we started on, a positive note, and we're ending at a positive note. Yes, people do believe that the draft code of conduct offers an effective code to regulate investment arbitration issues. Thank you very much for that. With that, we come to the end of this fantastic webinar. Thank you so much to all our wonderful panelists for their time and very insightful statements and opinions. We look forward to the final code, and the Investment Arbitration Subcommittee will also be providing its comments to the draft code, and we hope that they are useful. Thank you very much for your time, and that will be all from the IASC, Lars and me. Thank you so much.
Maybe one final comment for the 10% that haven't been convinced. Send your comments to UNCITRAL and ICSID by the 30th of November. Thank you.